Ladies and gentlemen, thank you again for your time. I ask that you go back in your deliberations and find me guilty as the highest count charge, possession with intent.
Thank you.
Thank you. Ms. Simpson, and please the court. Ladies and gentlemen of the jury, this is my first opportunity to address you directly. So again, let me reintroduce myself. My name is John Terhune. I want to echo what Ms. Simpson said in regards to thanking you for your service. This October, I'll be a member of the bar for 41 years. And during all that time, I've always thanked jurors because I know, as a student of the law, that our justice system in the United States, it does not exist short of a citizenry willing to come, give up their time to be able to sit and listen to facts and then apply law. We do not exist as a country if we do not have that. So sincerely, on behalf of myself as a 41-year member of the bar, Mr. Edwards, and my co-counsel, Ms. Lopez, we thank you for your service. 41 years later, after being a student of the law and a continuous student, I continue to be in awe of what the founders did when it came to creating burdens on the state. When the state, 200 years ago, they decided that if the power of the state was going against an individual, then there in fact was going to be a substantial burden on the state to be able to prove the elements of the case. And short of the state proving all of the elements of the case, and basically the Constitution and ultimately the case law came down to the state having a burden of proof called beyond and to the exclusion of a reasonable doubt. I wasn't here for jury selection. Some of you may have sat in civil trials where the burden of proof is basically a greater weight of the evidence. That's not the case in a criminal trial where someone is charged with a crime. The burden is absolute, and Judge Blackburn will give you the absolute definition of reasonable doubt. And you as jurors, it's one thing to kind of hear it when you're particularly going through jury selection. I think you'll find it's a whole different one when you're actually having to apply it. And you're now at that point in time in this case where you're going to have to actually apply that law specific to reasonable doubt. And when Judge Blackburn instructs you on reasonable doubt, she's going to tell you a reasonable doubt is not a possible doubt, a speculative, imaginary, or forced doubt. Those type of doubts should not influence you to return a not guilty verdict if in fact you have an abiding conviction of guilt. But on the other hand, if after weighing, considering, comparing all of the evidence, you do not have an abiding conviction of guilt, or if having a conviction, it is not one that is stable, but rather it kind of wavers and vacillates, then the case has not been proven beyond a reasonable doubt, and by law, you must find the defendant not guilty. That is precisely what Judge Blackburn will instruct you on in just a little bit, and it's going to be up to you as the jury to be able to basically take that burden and then apply that burden to the facts of what you heard testified to and the introduction of evidence that happened in this courtroom today. Now, I know this example that I'm about to give you is going to age me, and for any of you that remember this, it may age you just a little bit. And the explanation will be easy enough, so even if you don't remember it, I think you'll get it. Way back when, there used to be a Wendy's commercial. And this Wendy's commercial, they had this little old lady, and she was looking at the burger. And the famous line came up basically, "Where's the beef?" And when I was watching the state's case unfold, I was thinking exactly that. Where is the beef? Let's think about what was really, truly proven today in this courtroom. Number one, it was clearly proven that our client was driving someone else's car. And by the way, that was actually shown during cross-examination, not during the presentation by the state. Socrates used to say cross-examination is one of the greatest revealers of the truth known to humankind. That car did not belong to our client. It belonged to somebody else. What else was proven by the state? Basically that car, the person that owned that car, was a drug user. They had a medical marijuana license. They used drugs. Number three, what did they prove? They basically proved that our client was in proximity to drugs basically after they were the car was rummaged through and they found this kind of stuff. He was in proximity to that. Now, why is that important? And we'll go to the jury instructions because there's something that's hugely important in the jury instructions. I'll see if I can get you to the right page so you can actually read along with me. This would be the second full page. And it'll be about halfway down. There's a substantial paragraph. This is under the section of possession of controlled substance. And if you go just a little bit down from there, there's a substantial paragraph. And very importantly, in that substantial paragraph, it says, mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. What does the state prove? Basically, our client was in proximity to drugs that were in somebody else's car who was a drug user. Period. That's the case. To do anything else, you were stretching the facts. Now, Ms. Lopez, I thought, did a wonderful job in questioning the police officers. And I'm always deeply respectful of law enforcement. They have such a tough job to do. And I was so impressed with what the officer did in regards to maintaining the evidence to be able to protect it so that they could basically do testing on it. Remember, he had gloves. All the officers wore gloves. He testified they're trained to be able to do that. Why do you do that? We do that to maintain the integrity of the evidence. Whose burden is it? It's the state's burden. Not only did they not check any of those bags or the money or any of those things for fingerprints or DNA, they did not even make a submission. The officers testified they didn't test it. There is no evidence whatsoever that they even took the time to make a submission to be able to send it to FDLE to be able to determine, are there fingerprints on those bags? Are there fingerprints on those money? Any kind of DNA to be able to basically establish before a jury what the truth is. It didn't come out because it doesn't exist. Who is the burden on? State of Florida. What is the burden? Proof beyond and to the exclusion of a reasonable doubt. The founders felt like, a long time ago, and thank God it's been since then, if we're going to put somebody on trial for a crime, state, you've got a burden. And if you do not meet that burden, there is only one verdict to be had, and that is not guilty. If you think about it, the stop, he did not flee and elude. He pulled right over. He was not rude. He got right out of the car. He did not appear to be high. There is nothing in that stop that happened that would give any indication that this young man knew anything about where the drugs were, what there were, or whether there were even drugs in the car. Ms. Simpson has shown you a PowerPoint presentation with a picture of all the items sat out there on the driver's seat. That's not how they were in the car. They were all over the car. They were here, they were there, they were here, they were there. They had to go digging for that stuff, and then it ends up on the seat of the car. Ladies and gentlemen, what has the state proven beyond a reasonable doubt? Our client was driving someone else's car who is a drug user, and he was in proximity, and you will read the jury instructions. That is not enough. Proximity alone is simply not enough. Great. What other evidence do you have, state, to be able to put this person in a position where he could be found guilty of a crime? And the answer is they have none. They have none whatsoever. One moment, please, Judge. By the way, as you are reading that definition of reasonable doubt, on, I believe, the third page, it says, plea of not guilty, reasonable doubt, burden of proof. Get everybody on that page. Let me see which one that is to be sure. First, second, third page. Very important, and you'll see in that big paragraph exactly the definition of reasonable doubt that I gave you. But you will see farther down, 2 paragraphs. A reasonable doubt as to the guilt of the defendant may arise from the evidence, a conflict in the evidence, or a lack of evidence. We have a lack of evidence because they just didn't cross their T's and they didn't dot their I's. And proximity in and of itself is simply not enough to be able to find beyond a reasonable doubt the charges in this particular case. You would have to make quantum leaps of assumptions based on the evidence that was shown today. And that's what you're to be able to make a decision on. The evidence that came out today. And I would submit to you, ladies and gentlemen, on behalf of our client, The state has not carried its burden. And the only verdict in this particular case is a not guilty verdict, because the state of Florida did not prove the elements of this crime beyond and to the exclusion of a reasonable doubt. We thank you for your consideration. We ask you for a not guilty verdict for this young man.